Hello everyone, this is KOMAL, MATHUR, a legal intern at LEXIS and Company and a law student at Manipal University, Jaipur. So our today's topic or purpose of presentation is to discuss about insanity defense as a loophole for criminals. So what is insanity defense and how does it work? Insanity defense is a defense in which a criminal admits to the crime but claims a lack of understanding due to mental illness. As a result, it is more of an excuse than an explanation for what he or she did. In India, the defense of insanity is described in Section 84 of the Indian Penal Code. The law, sometimes as known as the law of insanity, protects an unsound-minded person and provides him or her with a defense against criminal culpability under Section 84. This law is based on the assumption that when a person commits a crime in a fit of insanity, he or she lacks the mental capacity to comprehend what he or she is doing and that if the act is illegal. For these reasons, insanity law has proven to be extremely useful in understanding an insane person's mental state and in appropriate circumstances granting them immunity for criminal prosecution. In Indian law, insanity can be used as a defense. Nothing is a crime if it is done by a person who at the time of commission was incapable of understanding the nature and consequences of the act he or she was performing and was also unaware of that it was prohibited by law due to the unsoundness of his mind. Analyzing the aforementioned section, it is clear that the provision is heavily influenced by the McNaughton's test, which is divided into two broad categories based on the 5-point proposition major criteria, which cover cases where the person was suffering from mental illness at the time of the crime, and minor criteria, which covers cases where the person was not suffering from mental illness at the time of the crime. First criteria was that the person was unable to comprehend the nature of the act. Second, that the person was unable to see that his or her actions were wrong. Third, that the person was unaware that what he or she was doing was illegal. Under both these conditions, the insanity is legal sanity, and the accused should be acquitted if it is proven. It should also be noted that Section 84 of the IPC is based on the fundamental concept of actus non facit reum nisi mens et rea, which means that nothing is wrong unless it is done with the intent to harm another person. Second is the furiosi nulla voluntas est, which means the person suffering from mental disease lacks free will and hence cannot do anything wrong. In this approach, Section 84 absolves a person suffering from the mental illness of his or her obligations due to an absence of mens rea or intent. Now, what is insanity in medical terms versus insanity in legal terms? The legal test for mental illness is laid forth in Section 84 of IPC. However, there is no exact definition of phrases like unsoundness of mind or insanity in the legislation. Therefore, they have varied meanings in the different situation and indicate varying degrees of the mental diseases. But there is a distinction between legal insanity and medical insanity, and the courts are solely concerned with legal insanity. A person with mental illness is not simply free from criminal culpability. To distinguish the two, a person suffering from mental disease is referred to as medical insanity, whereas in the case of legal insanity, a person suffering from mental disease also loses his or her reasoning power at the time of crime. Legal insanity refers to a person's mental state at the time of committing a crime, and thus is only a legal notion with no psychological underpinnings. Any one of three requirements of Section 84 as indicated earlier must be made for insanity to qualify for legal insanity, and only then can accused seek insanity as a defense. The Honorable Supreme Court held in the Babu Gajraj Singh versus State of Rajasthan that the psychopath's mental illness or partial hallucination, uncontrollable impulse or compulsive mind provides no protection under Section 84 of IPC. In Surendra Mishra versus State of Jharkhand, the Supreme Court held that Section 84 of Indian Penal Code applies to legal insanity and not to medical insanity, and that a person suffering from mental disease is not immune from criminal culpability. As a result, under Section 84 of Indian Penal Code, it is not necessary to prove that the person is suffering from mental illness, but it is also necessary to prove that the person was unable to understand the nature of his act and committed a crime. So that's all for today. Thank you everyone. Have a nice day.